Hello, in this video we will review the key points of the Simple Assignment of Claim Agreement. We applied our experience in over 5,000 transactions to create a middle-of-the-road simple assignment that fairly balances the interests of sellers and buyers. In paragraph 1, we define consideration as the cash you will receive and claim as the minimum claim amount, which is the face amount of the claim you are selling. The definition of claim also includes all distributions the debtor will pay out in the bankruptcy case and any voting or litigation rights you may have. In paragraph 2, you are telling a buyer you filed a proof of claim, and if you did not, you are stating that you have supporting documents sufficient enough to file a proof of claim in the minimum claim amount. In paragraph 3, you are making representations, warranties, and covenants as to the amount and validity of the claim. Representations, warranties, and covenants are technical terms that mean statements of fact and promises that the facts are true and reliable. Buyers need these statements and promises from a seller because the seller knows more about the events that gave rise to the claim than the buyer could know. Some of these key statements are that the claim is valid and enforceable in at least the minimum claim amount, which is the face amount you're selling. Other statements are pretty basic, such as you have not sold the claim to anyone else, the claim is free of any liens, and that the buyer is not responsible for any obligations or liabilities of the seller. Other important statements include that the claim is not subject to set-off, reduction, or preference action. In paragraph 4, you acknowledge that the cash consideration a buyer pays you could be different than the ultimate value of the claim in the debtor's bankruptcy case. You also acknowledge information about the case can be obtained from the bankruptcy court. In paragraph 5, you acknowledge the buyer may have more information than you, and you waive any claims you might have against the buyer as a result of information the buyer may have. Paragraph 6 states what happens if the claim is subject to an impairment. At this point, it's important to review the risk allocation between seller and buyer. When a buyer buys your claim, they take all the risk of how allowed claims are treated. For example, if the buyer pays 25 cents on the dollar for your claim, and the ultimate recovery per dollar of allowed claim is 10 cents on the dollar, that is the buyer's risk. If the buyer expects to receive a distribution in 1 year and allowed claims don't receive any distribution for 3 years, that is the buyer's risk. This makes sense because the buyer is a professional investor in bankruptcies. However, if any part of the minimum claim amount is reduced, set off, or disallowed, the seller promises to proportionally repay the buyer. This also makes sense because the seller knows more about the specifics of the claim than the buyer could ever know. For example, if the face amount of the claim is $100,000 and the purchase rate is 25%, the buyer would pay the seller $25,000 cash at closing. If the claim is reduced by $2,000 and ultimately allowed for $98,000, then the seller is required to repay the buyer proportionally. In this example, the repayment would be $500, the $2,000 reduction multiplied by the 25% purchase rate, together with interest. If the repayment occurred 1 year after initial closing, the interest would be $40, the $500 repayment multiplied by 8%. We think this is fair because if the parties knew the claim was going to be allowed in the face amount of $98,000, the buyer would have paid seller $24,500 at closing, or $98,000 multiplied by the 25% purchase rate. Paragraph 7 is designed to protect you if your claim is ultimately allowed in a greater amount. This greater amount is called the excess claim and is the difference between the initial face amount and the amount of the claim ultimately allowed in the case. This paragraph is the mirror image of the prior paragraph. For example, if the minimum claim amount was $100,000 and the claim is allowed in the amount of $110,000, the excess claim would be $10,000. If the purchase rate is 25%, the buyer would pay you an additional $2,500. Paragraph 8 is pretty straightforward. It states if you receive any payments on account of the claim after the sale closes, you need to send those payments to the buyer. Paragraph 9 states that you promise to make the buyer whole, together with buyer's attorney fees if any of your representations or warranties are false, or if you don't do things you have promised to do, such as repay the buyer in the event of an impairment as stated in paragraph 6. Paragraph 10 provides for the administration and transfer of the claim post-closing. It contains a limited power of attorney in case the buyer needs to take actions to validate their ownership of the claim. This paragraph also says that the buyer can file the evidence of transfer with the bankruptcy court to become record holder of the claim. There is also a provision that you agree to take further action appropriate to the assignment. Paragraph 11 says the assignment is governed under New York law and that the venue in case of a dispute will be a court located in New York City. It also states that both parties waive their rights to trial by jury. Paragraph 12 contains a standard confidentiality provision. Paragraph 13 contains miscellaneous provisions stating that electronic signatures and email delivery is permitted. It also states that the assignment contains the entire understanding of the parties and supersedes all prior agreements. Finally, paragraph 14 states that all rights in the assignment are cumulative and not alternative, meaning that if one right is exercised, it does not preclude the exercise of other rights. Please note that this video is meant to give you an overview of the simple assignment and does not constitute legal advice. Before entering into a transaction, you may want to consult legal counsel, and in any event, you should read the simple assignment in its entirety. We hope this overview is useful to your understanding of the simple assignment of claim. If you have any questions, email us at all@cherokeeacq.com.